Ladies and gentlemen, may I have your attention, please? The show starts in 10, 9, 8, 7, 6, 5, 4, 3, 2, 1, go.
Greetings, I'm Yasmin Ihsan. I will be starting off our presentation by elaborating on the roles of solicitors and barristers. I will also be highlighting the overlap between the two roles. Unlike most countries, there are two types of lawyers in England and Wales. These are barristers and solicitors, or jointly referred to as the legal profession. Other countries, for instance Malaysia, have no such distinction, as we are a mixed profession where a legal practitioner does the work done by both solicitors and barristers. Although solicitors and barristers are both legally qualified lawyers, there are some distinctions between the work of a solicitor and that of a barrister. Solicitors are so-called frontline lawyers that have direct contact with clients and provide a variety of legal services. Solicitors provide legal advice on a wide range of sectors, and it is not unusual for solicitors to specialize in a particular area. The type of work they do largely depends on the type of firm they work for. This can range anything from high street private firms to being employed in-house for industrial businesses, or they can even work in the government department, namely the Crown Prosecution Service. Solicitors working in this area are likely to spend most of their time interviewing clients to negotiate on their behalf, doing paperwork, and preparing legal documents. Prior to the Administration of Justice Act 1985, solicitors had a monopoly in the area of conveyancing, but the Act then enabled any layman to become licensed conveyancers. Solicitors have always had the right of audience in the magistrates and county court, but the right of audience in superior courts used to be very limited. It is not until the case of Apsey and Smith that the Lord Chancellor and senior judges in the High Court divisions issued a practice direction allowing solicitors to appear in High Court to make statements for cases that have been resolved. Major alterations were made to solicitors' right to audience through the Courts and Legal Services Act in 1990. This act enabled solicitors to qualify for a certificate of advocacy on condition that they've already experienced advocating in magistrates and county court, along with undergoing training and exams. It also made it that solicitors are now eligible for appointment as judges. The Access to Justice Act 1999 further expanded solicitors' advocacy work, as it contains a provision that all solicitors are to be automatically given full rights of audience. In practice, most advocacy work is done by solicitors, as the majority of cases are tried in lower courts where cases are mostly taken up by solicitors. Barristers, on the other hand, or collectively referred to as the bar, mostly specialize in litigation, particularly in superior courts. Barristers enjoy the right of audience in all courts throughout England and Wales. Because of this, the majority of barristers will concentrate on litigation, making a huge bulk of their service to consist of legal research, drafting legal documents for court use, and writing advice to solicitors. Unlike solicitors, all practicing barristers are required to be self-employed, but they are allowed to form a set of chambers where they will share administrative expenses. Before the implementation of the Direct Access Scheme by the Bar Council in 2004, the public had no direct access to barristers. If anyone wished to employ a barrister's service, it was compulsory for them to first consult with the solicitor, who would then brief the barrister. This system was widely criticized on grounds that it was creating unnecessary expense, thus making the legal service less accessible to the general public. The Bar Council responded to these criticisms with the Bar Direct, where clients can directly deal with barristers, as long as they are not criminal or family cases. The downside of this reform is that barristers now get the extra workload of dealing and negotiating with clients. Until the late 19th century, the functions of barristers and solicitors were largely distinct. Barristers focused on litigation, while solicitors did most of the preparative work and had little rights of audience. The difference between the two roles was brought closer by the Courts and Legal Services Act 1990 and Access to Justice Act 1999, where solicitors attained more advocacy rights. Another distinction was that barristers could not be personally briefed without a solicitor. The year 2004 saw a change to this system where barristers became more accessible, but then had to take over the preparatory works previously only done by solicitors. Through changes made by the Legal Services Act 1990 and Access to Justice Act 1999, the long-standing debate of whether or not the profession of barristers and solicitors should be merged have been put to rest. There is no longer a need for the two professions to be fused together as the roles have been made similar. Thus, both barristers and solicitors are capable of handling a case from start to finish. That is all from me. Now we'll move on to question 2. Thank you.
Hi, I'm Elissa Chiew. In fact, there are many ways in which lawyers could contribute. But what are the fundamental values of the English legal systems that lawyers are trying to uphold? To answer this, we look at what characterizes the English legal system that shapes its values. The English legal system has a long history, and tracing back to its development, it actually derived from the time when the common law emerged. So one of its most important characteristics is, of course, its common law inheritance, which forms the heart of the English legal system nowadays. The reason why I'm pointing out the common law system is because I would like to bring to your attention how it operates, which is going to be the basis for my discussion. The common law operates based on the doctrine of precedence, where past decisions of the judges create law for future judges to follow. And this is based on the Latin maxim stare decisis, which means stand by what has been decided and do not unsettle the established. The entire purpose of precedent is to support the idea of fairness and provide certainty in the law as like cases are to be treated alike. Having said this, the common law system is valuing fairness as one of its driving objectives. Hence, we can also say that the English legal system is seeking to uphold fairness as one of its fundamental values. So how can lawyers contribute to this? There are many ways, and one of them is through ensuring procedural fairness. The concept of procedural fairness is founded by the British principle of policy by consent. It is closely tied with the legitimacy of the police authority on the importance of fair treatment. In other words, procedural fairness concerns whether the procedure taken is fair in producing a just decision. But how is this concept related to our topic of discussion? Well, procedural fairness has mostly been considered within domestic criminal justice contexts. In particular, the procedures taken by police during their investigations. For example, in the case of Othman and United Kingdom, the applicant was deported from the UK to Jordan in the interest of national security. But he argued that if he returned to Jordan, he would be at a real risk of torture, and his trial would be flagrantly unfair. The court ruled in favor of the applicant, as he had proven that he would be at a risk of denial of justice if he were deported to Jordan. So in such example of cases, what lawyers can do to ensure procedural fairness is through defending for their clients whose rights have been breached. This is the role of barristers to defend for their clients. Another way in which barristers can ensure fairness is by abiding the cap rank rule. This is so that everyone has a chance to be represented by a barrister of their choice. Otherwise, those accused of violent crimes such as rape and terrorism could struggle to find appropriate legal representation if the cap rank rule is abolished. It is also very important that lawyers should not prejudge their clients. As mentioned earlier, procedural fairness is mostly concerned with criminal justice. A thing to note here is that in criminal cases, clients still do not have direct access to barristers. On this subject, solicitors can contribute towards ensuring procedural fairness by communicating well with their clients and making sure that they understand the legal procedures. For instance, they can help a defendant to understand the evidence that the police and prosecution are presenting against him through written communication. This is important so that the defendant is presented with transparent information in order to have a fair trial. Procedural fairness research tells us that if lawyers can improve the perceptions of people who come to court through this communication process, appearance at court would improve. And broadly speaking, the fairer the procedure, the fairer the eventual outcome. There is also evidence that improving procedural fairness can rectify perceptions of racial bias and inequality among the marginalized communities. So to sum up, fairness is one of the fundamental values of the English legal systems that lawyers should seek to uphold, since the common law system is trying its best to achieve justice. And to do that, procedural fairness is the first step in which lawyers could contribute. That's all from me. Thank you.
Hi, I'm Jiman. Apart from maintaining procedural fairness, lawyers could also defend the fundamental values of the English legal system by upholding the rule of law and judicial independence in the UK. One may wonder, what does rule of law stand for? David Dicey famously gave three meanings to the rule of law. Firstly, rule of law denoted the predominance of regular law and individuals could only be punished for breach of law. Secondly, no one is above the law. The same law will be applied to every citizen. Thirdly, the principles of the Constitution concerning the rights of the individual were the direct consequence of judicial decisions. So, how exactly do lawyers uphold the rule of law? This could be demonstrated in four aspects. First and foremost, when lawyers faithfully protect their clients' rights, they defend the rule of law. However, the lawyer's advice must reasonably assess the law and facilitate the accomplishment of the client's goals and objectives. Lawyers act as agents of their clients, but only within the bounds of the law. Secondly, in a broad perspective, one could assert that lawyers establish and promote the rule of law by drafting new legislation or amendments to existing legislation. Besides, the review of some items such as equality before the law, the supremacy of law, legal certainty, and other elements of rule of law affirms the presence of lawyers in realizing such concepts. Thirdly, from the aspect of political liberalization, lawyers defend the basic frameworks of rights to speech, assembly, petition, and free elections. Besides, lawyers also protect citizens against arbitrary arrest and imprisonment and prevent the minorities from experiencing discrimination. Lastly, the modernized conception of ethics of lawyers directed them to support the rule of law in their work in various ways. By integrating concepts such as equality, access to justice into their practice, they fulfill the essential role of lawyers in maintaining the rule of law. In the UK, judicial independence is traditionally portrayed as the backbone of the rule of law. To put it simply, judicial independence means that judges must be free to exercise their judicial powers without interference from litigants, the state, the media, or powerful individuals or entities, such as large companies. In order to realize judicial independence, judges have to decide cases impartially and in accordance with the law, and exercise their role as protectors of the Constitution without any pressure or interference from other sources. Moving on, I'll be explaining how lawyers in the Bar Association protect judicial independence against threats in the English legal system. When judicial independence is at risk, the Bar Association must be ready to offer their colleagues support to uphold the rule of law. The support can be in the form of public statements, formal complaints letters to the Chief Justice or ministers, lobbying the legislature, and utilizing the media. The Bar Association also has a role in aiding any judges who are under improper pressure from the government. Their pressure may be in the form of threats to their jobs, fines, and attempts to impeach. Individual judges often face serious criticism from the media and politicians, particularly when applying human rights legislation and in judicial review. Although according to Constitutional Reform Act 2005, Section 3, Subsection 6, the Lord Chancellor has a duty of defending the judicial independence. This is largely symbolic. When any judges is in conflict with the state, they should know that reliance can be placed on support from the bar. Furthermore, when media campaigns unfairly target judges, members of the legal profession must step forward to defend judicial decisions. In addition, the bar must speak up whenever the judicial independence is being threatened or undermined. It mustn't be reserved to identify and criticize any judges whose conduct exhibits a failure to respect independence. This must also extend to legislation which erodes judicial independence or reduces the scope of the judicial judicial will in litigation. In conclusion, lawyers must stand shoulder to shoulder with their judicial brothers and sisters in defense of an independent judiciary and the rule of law. As both of these concepts are close to the heart of achieving justice, which is the fundamental value of the English legal system. That's the end of my part. Thank you. Now I'll pass it on to Shu Wei to discuss how lawyers protect the fundamental values in the English legal system in another way.
Another way in which lawyers can contribute to upholding the fundamental values of English legal system is by ensuring the access of justice for everyone. Hello, my name is Shu Wei, and today I'm going to talk about accessibility to justice. According to the Supreme Court Chief Justice of Australia, Justice Bigeman, lawyers perform a critical role in the promotion of social order by the administration of the law in a manner which answers the fundamental requirements of justice. Namely, fair outcomes arrive by fair procedures. This applies to lawyers from all around the world. The responsibility that lawyers hold are important to the society. They are advocates and advisors, and they work to represent individuals and corporations in civil trials and to promote justice in criminal trials. However, according to the Law Society, demand for legal services in England and Wales in the year 2018 from individual customers, as in business to consumers (B2C), grew relatively slow compared with the demand for legal services from business to business (B2B). Increase in demand for B2B was reported to be driven by the overall growth in the UK economy, as well as the expected growth of specific sectors which have high demand for legal services, which is the financial services sector. Sometimes, the cost of bringing a case to court will be high and it is not affordable by everyone. The Law Society had considered that one of the main reasons for legal services B2C to creep slowly is due to the low income growth of UK households. Despite that, the need for an accessible judicial system should not be underestimated. Accessibility is to be found in the opening doors of courts to the public. This includes the provision of judicial services to the public at reasonable cost of the means to go to court for those unable to pay legal costs. One of the ways for solving this problem is that lawyers can provide pro bono legal services. Pro bono work is legal advice or representation provided free of charge for the entire case by voluntary legal professions in the public interest. This can be to individuals, charities, or community groups who cannot afford to pay for legal help and cannot get legal aid or any other means of funding. It helps people in the UK to get access to justice if they can afford to pay for legal help, which in turn, lawyers are contributing towards upholding the fundamental values of English legal system, which is access to justice. Citizens Advice, Free Representation Unit, Law Centers Network, and University Law Clinics are some of the non-government and charity organizations which provides pro bono support. When more and more lawyers engage in pro bono work, justice will be easily accessible by everyone regardless of their financial status. All persons are entitled to call upon the assistance of a lawyer of their choice to protect and establish their rights and to defend them in all stages of civil and criminal proceedings. Nevertheless, the community has insufficient awareness of their rights to turn to courts in order to defend their rights and obtain redress for wrongs. Professional associations of lawyers must promote programs to inform the public about their rights and duties under the law and the important role of lawyers in protecting their fundamental freedoms. There are a lot of ways to do this, especially in this modern era where the internet and social media is widely accessible by everyone. Lawyers can share expert opinions and start important discussions about ongoing legal battles and even bizarre cases through social media. It is not just about providing a legal view on public issues, but also to increase the public awareness to choose the right path when facing any dispute. Lawyers must act in accordance with natural justice. They must take this noble profession seriously and not only think of ways of fleecing their clients of their money. Lawyers who are only thinking of earning more money as their end goal are not upholding the fundamental values that English legal system reflects. Lawyers should provide legal aid without any distinction of kind, such as discrimination based on race, color, sex, language, religion, political reasons, nationality, economic status, and others. This is extremely important because lawyers' responsibility is to help people to stand on their own feet and deliver them justice at the earliest so that they do not have to suffer for the rest of their lives. To that, the contribution of lawyers to uphold the accessibility to justice is extremely important. And now, I'll pass it to Jia En to talk more about what lawyers can do to uphold other fundamental values that the English legal system reflects.
Hi, I'm Jia En. The next method in which lawyers can contribute to upholding the fundamental values of the English legal system is through ensuring public confidence in the courts. In the case of Japan, Justice Barrett held that public confidence in the judiciary is the most valuable wealth that this branch possesses. The courts can only execute their societal function as a dispute resolution institution if the public trusts them, and such confidence can be enjoyed when the court is being independent and fair during the process of resolving the dispute. Besides that, in Section 3 of the Israeli Basic Law Judiciary stated that, unless permitted by law or decided by the court, otherwise, a court must sit in the public. This rule is recognized by the Supreme Court and it supports the open court principle to ensure a fair trial. And pursuant to Article 6, Sub 1 of the European Convention on Human Rights, the Court of Appeal ruled that the Convention requires the judgment should be supported by sufficient reasons. Moreover, behavior of judges either on or off the bench is also restricted by public confidence. It is because the public confidence is maintained by proper judicial conduct and is adversely affected by judicial misconduct. Hence, there is always a constant tension between the judicial independence and public responsibility of judges. Therefore, in order to balance these two, the tension should be resolved by conducting wisdom and good judgment. Moving on, it is undeniable that lawyers play an important role in our society as an advisor to their clients of their rights and help the clients navigate the legal system. Lawyers also assist their clients by applying law to the case with the best interest of their clients in mind. Hence, there are a lot of essential ethics standards to regulate a legal profession. It also can be said that a lawyer's ethics is one of the methods to upholding the fundamental values of the English legal system. So, what are the ethics? Ethics is a set of set rules to ensure that the lawyer obeys the law, pursue justice, and properly conduct the law in the daily law practice. It is so important to a lawyer to promote these ethics while practicing in law because lawyers are an indispensable part of the lawmaking process, and the rule of law itself is based on the principles of justice, fairness, and equity. A collective reputation is very important because it is linked with the public perception to the administration of justice of a legal profession. Therefore, the reputation of lawyers will be destroyed if the lawyers do not adhere to the ethics, and subsequently, people will resort to other ways to resolve their conflict. If the public is dissatisfied with the justice system, the rule of law will fail. Since we know that why the ethics are important to the lawyers, now I will explain more about the methods for ensuring ethics so that the fundamental values of the English legal system are upheld. One of the methods can be seen in Principle 28 and 29 of United Nations Basic Principles on the Role of Lawyers. It has stated that disciplinary proceedings against the lawyers will be decided by an impartial disciplinary committee in independent judicial review. Besides that, a legal profession has a duty to raise awareness of ethical duties amongst the lawyer, and it has to take responsibility to ensure that the lawyers had received the training on ethical standards. Apart from that, awareness amongst the public is also an essential way to ensure ethics. It provides the public to examine whether the lawyers have performed their duties strictly. Hence, the rules of ethics should be clearly written and must come to the knowledge of the public. And the last method is by adopting regional or international standards on ethics. If a bar association or law school does not possess their own code of ethics, it may take reference from international or regional lawyers associations who already have a well-established code of ethics. In conclusion, lawyers should practice good ethics so as to ensure that the fundamental values of the English legal system are protected. As mentioned earlier, these fundamental values, including procedural fairness, the rule of law and judicial independence, the access of justice for everyone, public confidence in the courts, and lastly, adhere to lawyer ethics. That's all from me. Now I'm passing the floor to Ivy and Kelly. Thank you.
name is Ivy. Next, Kelly and I will be taking on the attributes that lawyers should possess in order to carry out their roles effectively. We agree with the fact that lawyers should possess ethics such as decency in order to carry out their roles effectively, especially when lawyers are giving legal advice to their clients. I also agree with Jia En that lawyers should have integrity, honesty, respectability, as well as good customer service skills in order to achieve those ethics principles. I would like to emphasize on this point by using a court case. Lawyers have to make sure that they do not damage the reputation of the English legal system, as this will affect the confidence of the public. One of the example cases is Arthur J.S. Hall and Court and Simons, where the court held that the advocates such as the barristers were omitted from practice in both civil and criminal affairs. According to Lord Stan, abolishing this rule of immunity for advocates will strengthen the legal system and boost the public confidence, as it is unfair for the advocates to be immune from liability in negligence if they are found to be in breach. When barristers are not immune from the liability in negligence, they ought to assist their clients through lawful means to achieve the right to fair trial, and also the clients have the right to legal representative. Therefore, the lawyers should not refuse to help the clients and assume the clients are liable themselves to ensure the principle of nemo juris causa sua, and this can be seen in the cat rent rule, where the barristers are prohibited to refuse the clients when they are free to take up the case. Through this, natural justice is upheld. Thus, it is clearly seen that the lawyers have to ensure integrity when helping the clients rather than the interest they will get. Therefore, we agree that lawyers should act ethically and morally while providing legal services. Apart from that, we also agree that lawyers should also possess commitment to professionalism, that is to keep the privacy of the client's information safe. When providing legal advice, lawyers should not disclose any information about their clients. The lawyers will have a better idea to help their clients, as they will be more likely to share the truth rather than providing incorrect information to their lawyers. Lawyers should obey this duty stated in Legal Services Act 2007. Section 1, subsection 3, Paragraph E of this Act stated that it is essential for the professionals to keep the information of the clients confidential. According to Lord Ray in the case of Argyll and Duchess of Argyll, this confidentiality rule was intended to ensure the confidentiality of the information, as the court cannot insist on investigating the case if the defendant is proved not guilty. When the lawyers reveal the information of their clients without consent, they would be held liable due to misappropriation of the closed information. Consequently, the reputation of the lawyers would be tarnished, as clients do not think that the lawyers are reliable. Despite this, there are still some circumstances where lawyers are obligated to disclose the client's information based on the Solicitors Regulation Authority. The example situations where the lawyers are allowed to review the client's information include the situations where the client is suspended to commit suicide, children who are suffering from sexual abuses but they are afraid to voice out, and to ensure that the client will not participate in the crimes in the future. In these cases, the lawyers are encouraged to review the information of the clients so that they are able to provide the most suitable methods for the clients to address the concerns based on the situations. Therefore, even though we agree that lawyers should have commitment to professionalism to not disclose the client's information, there are some exceptions. In conclusion, it is undeniable that a good lawyer should merge basic values which are commitment to competence, such as good customer service skills, commitment of ethics principles, such as integrity and honesty, as well as commitment to professionalism, which are the ability to keep the confidentiality of clients' data. Thank you.
Hello, I'm Kelly. I agree with Ivy that a good lawyer should possess the attribute of a commitment to professionalism, which transfers the public interest into the other values. Hence, I will be talking more in depth on why lawyers should possess the ethic of professionalism. Professionalism is the combination of all the qualities that are connected with trained and skilled people. A lawyer should have strong interpersonal skills as lawyers interact and work with a variety of diverse clients. A lawyer should provide objective advice and strive to represent the client's interests as expeditiously and efficiently as possible. Lines of communication must be kept open and explanations provided for actions taken in the course of representation. In B and Upland District Law Society, Lord Miller justified legal professional privilege on the ground that a lawyer must be able to give his client an absolute and unqualified assurance that whatever the client tells him in confidence will never be disclosed without his consent. A lawyer has a duty to act in a manner consistent with the proper functioning of a fair, efficient, and humane system of justice. In Arthur J. S. Hall and Cole and Simons, Barrett and Ansell and others, Harris and Scofield, Roberts and Hill and another, 3 clients are suing their solicitors for negligence. Lawyers conducting litigation owe a divided loyalty. They also owe a duty to the court and the administration of justice. They must cite all relevant law, whether for or against their case, and may not make imputations of dishonesty. As an officer of the court, a lawyer should act with complete honesty, show respect for the court by proper demeanor, and act and speak civilly to the judge, court staff, and adversaries with an awareness that all involved are integral parts of the justice system. A lawyer should also strive to protect the dignity and independence of the judiciary, particularly from unjust criticism. The next attribute a good lawyer should possess is a commitment to competence, which is about skills. Skills is the art of doing a thing as it ought to be done, practical knowledge in combination with ability. A great lawyer must be orally articulate and have good written communication skills, as strong oral and written communication skills are crucial, which give clients confidence in the lawyer. Verbal communication is the most vital element of the job. Good public speaking skills are essential, as lawyers need to be a confident speaker when arguing a case in court, communicating arguments to persuade the judge or jury of the merits of the case, negotiating settlements, and explaining complex information to clients. It is necessary to use persuasive, clear, and succinct language. In Three Rivers District Council and others, and Governor and Company of the Bank of England, Mr. Sumption, Queen's Counsel, stated that communications between lawyer and clients constituting advice and assistance of a kind which is a part of the proper function of a lawyer to give by virtue of his legal skills. Written ability is equally important when drafting letters and legal documents. Lawyer has to know technical and legal language and be able to write clearly, persuasively, and concisely, as they must produce a variety of legal documents. A good lawyer has to be good in many aspects. To summarize, the attributes should be possessed by a great lawyer are commitment to competence, ethics, and professionalism. Thank you.